As the first speaker this morning, I would like to express my gratitude for inviting me to participate in this Congress and indeed for holding this important Congress, to the Rector of the University of Girona, to the Dean of the Law School, of course to the city, this marvelous city, and above all to Dr. Jordi Ferrer, who is famous in my university in Oxford, principally for his academic credentials and for the wonderful conferences that he has organized, but equally importantly, and for some people perhaps more importantly, is the gastronomic experiences that Professor Ferrer has extended to his visitors from Oxford. And I'm not surprised that they want to come again and again. Having spoken for about Dr. Ferrer, I want to take my cue for my talk from his lecture that he has submitted to the conference. He starts with some basic observations about the function of the judicial process. The function of the judicial process, especially in a country governed by the rule of law, is to establish the truth and to apply the law to it, the correct application of the law to the true facts. Now, it establishes the truth by drawing inferences from evidence. But the conclusions reached on the basis of evidential support are always a matter of probability, not certainty, he points out, and therefore there is always a risk of error. A risk of error is completely inevitable. So we start with a proposition that the court has to establish the truth, but we also know that there is always the possibility the court has made a mistake. So the question arises, how can we be confident that the court judgment is true, is correct, is in accordance with the facts as they happen? What is it that gives us this confidence, without which, of course, there is no point of going to court? And this is the problem that we are all going to discuss today. The confidence in the outcome, the confidence in the truth, is a function of the confidence that we have in the procedures that have been employed to reach the truth. Because there is no mega test for judging whether a particular judgment, whether a particular decision, whether a particular factual conclusion is true or false. There is no mega test for judging this. The only test that we have is the test of the procedure. Do we have confidence that the procedure is appropriate, that the procedure is likely to lead to the truth? And in this context, and against this background, I want to draw your attention to attempts made in England to make rather fundamental changes to the time-honored procedure. What is the time-honored procedure in the judicial context? The time-honored procedure in the judicial context is the adversarial process. The adversarial process in the following sense, in the sense of a separation of functions, a separation of roles between the parties on the one hand and the court, the judge on the other hand. The function of the parties is to define the issues in controversy, to search and bring evidence before the court, to test the evidence of the opponent, to put forward the legal argument, and debate, and engage in a debate about the law and the facts. The function of the judge is entirely different. The function of the parties is adversarial. Functions, they contradict each other, they oppose each other. The function of the court is limited to deciding the case according to the evidence. The function of the court is to consider the evidence presented by the parties, the arguments presented by the parties, and to reach an impartial decision. In England, there are attempts to move away from this process. The main reason for these attempts is money. In England, as indeed in all the Anglo-Saxon world, litigants in civil cases, and indeed in criminal cases, have a right, considered the basic right, to represent themselves. They have a right to refuse legal assistance, not to use lawyers, but to act as their own representatives. They are called litigants in person. Litigants in person, of course, in civil and criminal proceedings, suffer, of course, from a deficit of expertise. So they don't understand the procedure, they don't understand the law, they make poor representatives for themselves. They make mistakes, and therefore they are vulnerable to higher risk of errors. They are vulnerable to losing the case, even though they are correct on the merits, because they haven't presented the case, the law properly, they haven't relied on the right provision, or they have made procedural mistakes. Until 2013, that wasn't a big problem, because until 2013, we had relatively generous legal aid, so that litigants who didn't have the means to employ lawyers would be given legal representation at public expense. Since 2013, legal aid has been abolished in all civil cases, almost all civil cases. There is no more legal aid in civil cases. As a result, many people who can't afford lawyers but who have legal problems now represent themselves. So there has been a very dramatic increase in the civil courts of litigants in person, unrepresented litigants, litigants who represent themselves. That, of course, has created an efficiency problem, because litigants who are not expert in procedure make many mistakes, make it more difficult for the court to manage cases, cases take much longer, the court, the administrative staff has much greater burden, it has created backlog, delays, inefficiency. And of course, there is the justice deficit, the deficit that they suffer as a result of being unfamiliar with legal proceedings and the law. To address this problem, a committee has recommended that in the case of litigants in person, when the court is faced with unrepresented litigants, it should employ some inquisitorial elements. It should introduce into the process, the court, the judge himself or herself, should employ inquisitorial procedures. And which means that helping unrepresented litigants to define the issues, helping them put questions to the witnesses, and helping them cross-examine witnesses. In addition, we are about to see the introduction of online legal proceedings where the claim is put down online, the judge then reviews the claim, and then the judge orders or makes provision for the appropriate means of developing the claim on behalf of the litigant in person. The whole online procedure is intended for claims up to about 30,000 euros to enable people to make claims without legal representation. So the present understanding of the English court is that it cannot treat litigants in person as it treats represented litigants, litigants with lawyers. It must make special provision for them. It must help them, while at the same time maintaining its impartiality as between the parties. And the purpose of my talk today is to argue that it is impossible to do both. It is impossible at the same time to provide meaningful assistance to a litigant without a lawyer and maintain impartiality. These two functions are incompatible with each other. And again, I come back to the traditional adversarial process. The traditional adversarial process is based on a separation of function between the judge who decides the case on the basis of the evidence and the arguments presented by the parties, and the parties who present the evidence, develop the arguments, define the issues, of course, and act in an adversarial way. The reason for this separation of power is the understanding, the intuitive understanding that people have always had at all times and in all places, that there is something wrong about the judge as it were representing one party. There is a principle, an old principle, that a judge should not judge in his own cause. My argument is that the minute the judge helps one party to develop her cause, he becomes a judge in his own cause. And that intuitive understanding, that intuitive perception that there is something wrong about the judge judging his own cause has now been affirmed by a great body, a large body of experimental evidence, experimental psychology. It has been shown time and again. In fact, these experiments started some 50 years ago, in the 60s. It shows that people who become involved in an investigation, any kind of investigation in any area, whether science or arts or history, and certainly in law, develop a hypothesis. The first step in an investigation is developing a hypothesis about what happened, how it happened, what it is. And once a person has developed a hypothesis, they become biased unconsciously and unintentionally. They become biased in favor of their hypothesis in the sense that they look for confirmation of the hypothesis and tend to overlook evidence that rebuts the hypothesis. And I emphasize, this tendency is universal, is shared by all of us. It's unconscious. People don't realize that it happens, that it takes place, and it is common both to experts and amateurs. There is no expert in any field which is above the confirmation bias, above this bias. And interestingly, the bias affects both judges who are unaware of it and judges who are aware of the bias. And I want to give you two examples. In the last few years, we have had in England a big scandal of child abuse. It was so big that the government had to establish a governmental inquiry to look into child abuse. Historical child abuse, not child abuse yesterday, but child abuse years ago. And they appointed as a chairman a very distinguished judge of the High Court, very distinguished and experienced judge of the High Court. She was appointed, this judge, and it then transpired that her brother had been, during the relevant time, Attorney General, and may have been involved in the decisions not to prosecute some of these people who were accused of child abuse. So there was a lot of pressure, public pressure on her to resign because bias. She said, there is no reason why I should resign. I am a professional judge. I am trained to assess evidence objectively, impartially. I'll go with the investigation wherever it takes me. It showed great insensitivity, but not just insensitivity, but ignorance of her own limitations. There is no person in the world who can get away from this confirmation bias. Not only was she liable to confirmation bias, but also there is another type of bias which is called in-group bias, also established by experimental psychology in extensive research. In-group bias is bias in favor of people who belong to your group, not in the sense that you want to reach a decision that would favor them, but you understand them better. After all, we draw inferences from generalizations, and these generalizations are formed by experience in our time, in our society, in our social background. So, of course, she must have had some sort of bias in favor of her brother, who she knew to be an honorable man. Eventually, she had to resign. Now, the interesting thing is bias when the judge is aware of the confirmation bias. So it has been shown in the United States that early female judges who judged rape cases were aware of their own tendencies to punish more heavily rape offenders and overcorrected so in order to resist their, what I would call intellectual urge to punish the offenders, they felt that that was not appropriate, that was not impartial. So they overcorrected and gave rapists lower sentences, lighter sentences than should otherwise have been given. Well, this is no longer the case now that the female judges are normal and common feature of the administration of justice. So the interesting thing is that there is both, the bias can work when you are unaware and also when you are aware of the phenomenon. What are then the strategies for overcoming distortion? Because as I've said, this is common to any investigation of facts. So in science, it's very simple. No theory is accepted until no experiment is accepted until it has been replicated and until the reasons for the conclusions have been verified by the scientific community. We can't do it when we are concerned with research of the past. So in history, for example, hypotheses about the past in history are tested in the market of ideas. For every historian that proposes a particular interpretation of the past, there are other historians that would contradict it, and there would be, therefore, a public debate and some kind of understanding may be formed. Understanding which is, of course, liable to be changed in the light of new interpretations. But this measure of market of ideas is not available in the judicial process. In the judicial process, we don't have room for debate about the correctness of judgment. Judgment has got to be final, decisive, and bring an end to the controversy. So the only measure available to securing correctness of judgment is the adversarial process, to remove the judge from the investigation of the issues, from the definition of the issues, from the questioning of witnesses. And not just for the questioning of it, to enable the judge to stand back and not get involved emotionally with any litigant. Because the minute you get involved with a litigant, either you feel yourself committed to the cause because you have helped develop the argument for the litigant, or you get annoyed with the litigant. And that's not good either. So either way, the only guarantee that we have that the judge would decide the case impartially according to as objective a reasoning as she or he can have, the only way of doing it is by removing the judge from the investigation. And judges in England understand that. And I want to give you an example. In a case, this was an appeal to the Court of Appeal arising from several cases which had one common feature. And the common feature to all these cases was that the father of a child made an application to court for access to the child. The mother, in all these cases, refused to allow the father access to their child, to the child of the father and the mother. And the reason, there were various reasons, because there are several cases, but the reasons were mainly with sexual abuse. Either some mothers claimed that the father had raped them, some mothers claimed that the fathers had abused a child of the family, and that was the common feature. In all these cases, the fathers denied the mother's allegation. In all these cases, the fathers were not legally represented, did not have lawyers. And since the fathers denied the mother's allegations, the mothers had to testify. And in England, the opponent has a right to cross-examine the witness against him in this case. So the fathers wanted to cross-examine the mothers on the evidence of abuse. Now, in criminal proceedings, where a person is accused of rape, the accused cannot in person cross-examine the victim. It's not allowed for obvious reasons. But this provision doesn't apply in civil cases. It was a family case. It was not a criminal case. And the fathers have a constitutional right to cross-examine, of course. So the first option that came to mind is the option that the judge would put the questions to the witness, as is envisaged in the new rules of civil procedure, and indeed the rule of the family court procedure. But then the judge said to himself, in this case it was a judge, he said to himself, but look, in order for me to cross-examine the witnesses, I have got to take advice from the father. In other words, I've got to have a conference in private with the father and ask the father what cross-examination to conduct. Well, this is completely inappropriate in an adversarial trial to have a private conference with one of the parties to take instructions. So there is no legal aid at public expense, so the court decided to pay from its own budget, to pay a lawyer to conduct the cross-examination on behalf of the father, because it wouldn't allow it would not be appropriate for the father to cross-examine, and it would not be appropriate for the judge to cross-examine. So when it comes to the actual machinery, to actual conduct of the case, of course, some judges, at the very least, some judges realized that it is incompatible for a judge, it is inappropriate, for a judge to conduct cross-examination. And if it's inappropriate for a judge to conduct cross-examination, it's equally inappropriate for the judge to tell or to advise a party what questions the party should put to the witness. Another advantage, of course, of the adversarial process is that the judge cannot be blamed for the outcome. If the judge is not in charge of the investigation, if the judge is not in charge of defining the issues, of deciding what evidence to present, the judge cannot be responsible for the outcome. Of course, if the judge takes part in the investigation interpretation, the judge can be held responsible, and that's not good for the system. Now, what is it in the English mind that allows it to contemplate inquisitorial proceedings in legal cases? Well, what is in the judge's mind or policymaker's mind is the idea that inquisitorial proceedings exist in continental Europe. That in France, in Germany, in Italy, in Spain, you've got inquisitorial proceedings. But that is, of course, a misunderstanding of the continental procedure. It is true, particularly in criminal cases, that the investigation of the crime is often managed and conducted by a judicial officer. The Pubblico Ministero in Italy, the juge d'instruction in France, or the parquet in France, and all these judicial officers have the status of judges. And I assume it's the same in Spain. They have the status of judges, but they don't judge the case. They only present the case. They are not judges of merits. The decision is never taken by the Pubblico Ministero or by the juge d'instruction or by the parquet. The decision is taken by the judge of merits, and the judge of merits is completely separate than the investigative judge. So there is a misconception, a myth about this wonderful inquisitorial procedure that exists in continental Europe. So, given if it doesn't exist in continental Europe, where you do involve the judiciary in the investigation, but not in the where you involve the judiciary investigation, but you do not allow the investigative judge to decide the case. If even in these systems you don't allow inquisitorial proceedings on the merits, on the contrary, in many European countries, including Italy and Germany, legal representation in civil cases is obligatory. If it's not obligatory, as in Belgium, then the court has discretion to order legal representation if it considers that it is necessary. So given that the European model does not offer any assistance to the introduction of inquisitorial proceedings in England, and given that they are deeply flawed in the sense that they undermine the security that the adversarial process gives us, it is bound to fail. And I hope our experience will show it. Thank you very much for your attention, and I hope that we can develop some of these themes by a discussion following my lecture. Thank you very much.
Thank you very much, Professor Zuckerman, for this interesting and relevant presentation. And now we have more or less 30 minutes, Jordi, 30 minutes in order to questions, suggestions, criticism, I don't know, to the presentation of Professor Zuckerman. This open debate. Yeah. If it's possible, please, the person with the word could introduce himself or herself for knowledge of all the audience. Yeah. Thank you.
¿Puedo realizarla en español?
Yes, could I speak in Spanish? Yes, I'm going to be asking Professor Zuckerman. Yes? Okay. Fine. I'm a student. I'm studying law, and I have a question for Professor. Well, two questions, really. First of all, of course, thank you for your presentation. And now let me go on to the questions. The first one, do you think there is a convergence in the systems of Anglo-Saxon common law countries? Is there a convergence of inquisitorial and adversarial pathways, so to speak? Are they converging? And my second question is towards the future. Is there a system that will prevail over the other? Or is it going to be maintained the way it is now, where in the continental systems we'll have the inquisitorial processes and in common law it will be adversarial? What do you think? Thank you.
Well, in continental systems, you have a kind of inquisitorial process in the sense that, particularly in criminal cases, not in civil cases, in criminal cases, the investigation of the crime, especially serious crime, is conducted or supervised by a judicial official. And I don't think we are going to have that. On the other hand, this judicial official in Spain, for example, doesn't decide the case. What is the Público Ministero called?
Fiscal.
Fiscal. The fiscal doesn't decide the case. The fiscal has to present the case before the criminal court where the defendant is represented, and there will be the same kind of adversarial process that we have in England. There will be the prosecution on the one hand and the defense on the other hand. So there is already convergence. It's not just convergence, it's universal, that the process is adversarial. Now, as far as the civil process is concerned, so I am speaking from my knowledge of the German procedure rather than the Spanish procedure, but in the German civil procedure, it is true that the judge is more active in the definition of issues, and it is true that the judge puts the questions to the witnesses. But the German judge puts only those questions that the lawyers have suggested to him. Because how can the judge, who has not collected the evidence, who has not constructed the legal arguments, how can the judge know what questions to put to the witnesses? So although the judge formally puts the questions are devised by the parties, not by the judge. So it is an adversarial case. It is an adversarial process in civil cases, both in Germany and in England. So there, you see, maybe this kind of talk encourages British policymakers to think that there is an adversarial process here. There isn't. Sorry, an inquisitorial process here, which there isn't.
Thank you, Professor Tuzet.
Wondering whether there is a difference in your view between the cases where just one party is a litigant in person and the cases where both parties are litigants in person.
Yeah.
The intuition is that in the latter case is less alarming, so to say, than the first.
Well, if both litigants are litigants in person, and the judge has to help both develop their cases, you could say, well, in this case it's better balanced because it's an obligation, doesn't develop a particular attachment to one case rather than the other. You could say that. On the other hand, intellectually, you must, when you develop the case for them, intellectually, you must realize that one is stronger than the other. And once you have made this, you have become conscious of that. It's not a decision, of course. Once you become conscious of that, then you are liable to the confirmation bias. Also, when you get involved with both of them, maybe one of them is nicer to the judge, doesn't annoy the judge, the other annoys the judge. It's difficult to maintain complete impartiality. But I see the point. I see the strength of the point.
Buenos días. En América Latina.
Good morning. In Latin America, all countries have gone towards a criminal system that is based on accusation and is adversarial. But in civil law, there is the consolidation of a strong movement of countries going towards an inquisitorial system, at least in civil law. Do you think it is possible that in one same country, judges can be trained so that in criminal procedures they respect litigation and they are inquisitorial in civil subjects? And how do you think this has an impact on the lawyers? Because lawyers can litigate in an audience, in a court, with adversarial rules, and in others with an inquisitorial model then.
Firstly, I don't think, and that has been shown by scientific experimental psychology, you cannot train a person not to be susceptible to confirmation bias. It's impossible. It's impossible in science, it's impossible in anything. That's the first thing. Secondly, I don't understand what the nature of the South American inquisitorial civil process is. I don't understand. I don't know what it involves. Perhaps you could explain.
Please.
Yes, for inquisitorial system, we understand the system in which the judge has the ability to promote the process, similar to the case management tools that you have in Anglo-Saxon countries, well, in England. And then as well, it's a judge that has strong conciliations during the procedure, looking for agreement between the parties. And then in the audience of the court, the judge in many countries starts the examination of the parties and even the counter-examination of the parties. And the role of the lawyers during the court is secondary. So they ask when the judge has finished asking.
Right. Okay, I understand it now. Firstly, both it is now also common in common law countries, in Anglo-Saxon countries, to have managerial judges. The judge manages the case. The judge is responsible for the conduct of the case. But this responsibility is limited to questions of efficiency. So the parties don't spend too much time questioning witness. Exactly. That's the idea. The idea is this. But firstly, so what has happened in England is that we have had managerial courts, managerial judges since 1999, and cases are managed indeed more efficiently and more effectively, and there are fewer delays, but the costs are much more than they used to be. Every reform of civil procedure designed to reduce costs has resulted in higher costs. That goes back many, many centuries in the English legal history. So, but the managerial judge is very different from a judge who develops. It just manages the way in which the adversarial process is conducted. So that's not incompatible with the adversarial process. Also, our judges try everything in their power to reach a compromise, to help the party reach a compromise so that they don't have to judge. So this is common. We don't yet have a procedure where the judge suddenly takes over the investigation, questions every party, questions the witnesses. We don't have that. And we are unlikely to have it except in the case of litigants in person.
Something else?
Yeah, that's...
Yeah.
Professor Zuckerman,
Professor Zuckerman, Professor Zuckerman, I coincide in that. Yeah, I'm fine. I'm fine. I coincide, Professor, in that any investigation, especially when it refers to fact, has to start on a hypothesis, and this generates in the person doing this a bias for confirmation. But I would like you to think aloud or give us your reasoning about a specific part of any judicial procedure, and that is that in a judicial procedure, the judge does not choose the hypothesis for research, but rather the research hypothesis is to be found, first of all, in the law, and second, it is referring to the facts that the parties invoke, kind of accusation, accused, the two parties in their initial writings. So the judge then cannot do away, cannot just forget about these hypotheses. Eventually, the judge, well, in any case, will select some of the hypotheses and will do the research, the investigation, And if there is no confirmation, then the judge will go and do the investigation on the other hypothesis. But the judge does not have the freedom, as is the case of the researcher in science, for example, or in history, where they are free to select hypotheses. Judges are not free. Eventually, the judge will, yes, indeed, go on maybe to a third hypothesis, to the extent that out of evidence, what happens is that there are parts of reason and legitimacy in each one of the hypotheses put forward by each party, but the judge cannot do away with those hypotheses of the parties. And this, Professor, and I would love you, if possible, to think about it, limits a lot this confirmation bias that in the field of psychology has been proven that, yes, exists in any investigation task.
Yeah. That's absolutely correct. I entirely agree that in an adversarial process, the judge is not limited to one particular hypothesis, and this is the strength of the adversarial process. Not only that, of course, at a certain stage in the reasoning, in assessing the evidence and the hypothesis presented by both parties, the judge would tend to one hypothesis, as is inevitable, because after all, the judge has to decide. And in this respect, he may be influenced by in-group bias, all sorts of other biases. But what is the strength of the adversarial process is that all these choices between different hypotheses are transparent, because both hypotheses have been, the hypotheses for both parties have been presented, the evidence has been presented, it's all transparent. And that helps, of course, the appeal process as well. Whereas if you allow the judge to to build a case himself, as indeed the Pubblico Ministero does, or the equivalent in Spain does, that particular investigative judge will make all sorts of choices, conscious and unconscious, which are not transparent. But that is not possible in an adversarial process with both parties present their cases. But I agree with you. You are entirely correct that the adversarial process combats the confirmation bias.
Sorry, how many people want to ask? 1, 2, 3, 4, 5, well, 6. That's okay. I ask you for a concretion of the questions, please, because we have now 10 minutes more or less, and that's okay. Yeah.
Buenos días, profesor. Buenos días.
Good morning. Thank you very much for your presentation. I will be very brief. I am from Puerto Rico, where we have a system of private civil law based on Spanish law. And we have public law that includes or is based on North American law. Because, as you know, we are a territory of the United States of America. So our probatory law is based on North American federal rules. It's practically a translation. But in civil cases, we have problems like the one you point out, because there is hardly any aid at all for people with no economic resources in civil litigation. We have a rule that allows for self-representation, but this rule dictates that those that self-represent have to know law, substantial law, and procedural law, and that they can't expect to be helped by the court. So my question is, is this problem really rather something to do with procedures? Wouldn't it be preferable to have kind of, I don't know, procedures based on referees or arbitration or adversarial law in some cases, especially for those people that don't have any financial means and consumers, instead of judicial procedures, make them different based on arbitration as an alternative? Thank you.
Right. This question brings out a very interesting phenomenon, a phenomenon of justice without lawyers. People want to achieve justice without lawyers in all sorts of fields, in all sorts of contexts. For example, in the United States, in New Zealand, and some other countries, there are all sorts of schemes of no-fault compensation, getting rid of lawyers in awarding damages for accidents at work, for road accidents, this sort of thing. There is now a phenomenon of mandatory arbitration in consumer contracts, particularly with IT companies. And of course, judges try to get rid of cases by getting the parties to conciliate and reach a settlement. I happen to believe that there is no justice without lawyers. The law is complicated. The law governs social activities in economy, in commerce, in health, in all sorts of fields. It's inevitably complex. It inevitably requires expertise. So justice without lawyers is like National Health Service without doctors. The trouble is that the lawyers are their own worst enemies. The problem in England is the cost. The cost of litigation is phenomenal. And every time a proposal is made to reduce costs in a serious way, the legal profession objects. The legal profession is very strong. So it's not so much, it's really an economic problem. We have got a very strong organized interest group which prevents us from really having affordable legal proceedings, affordable law enforcement.
Well, if Professor Zuckerman agreed, we could put together the questions, final questions, in order.
Fine, you are the boss.
Yeah, that's okay. That's okay. We could. We put together all the questions, final questions, 5 questions. Professor answer at the end.
No sé cómo pretende unirlas. Mi nombre es Olga Saloma, estoy hablando aquí, señor. Aquí, sí.
Sorry.
No, está bien.
No, that's okay, sorry. I come from Argentina, from hinterland, the province. In Argentina, we have what we call the beneficial litigation without expenditure. That is, we forbid the participation of the party in self-defense. We have mandatory legal representation for any kind of court procedure, including when there is mediation or arbitration. Even then, if it is decided from court, there must be legal representation. For us, that guarantees inclusion and it guarantees access to justice. That in the first place. And second, regarding evidence, yes, we do have modifications and changes in the proceedings that make it possible for judges to participate more in the evidential reasoning. We call it the immediacy principle. And that is, the judge listens to the parties, but asks questions, poses questions. We have right now created in our province what is called a cause audience, in which all the oral evidential reasoning is put forward. And I just heard that lawyers have a secondary role to play, but truth be told, the judge, has a lot of protagonism, but it will really depend on the lawyers in our case, in my province, because the possibility to act of the judge depends on the lawyers. Because questions, the judge is the kind of conductor, but the case is led by the lawyer. What I do believe is that in any one of the cases that was mentioned up till now, the fact that one party has a lawyer and that the other party does not have a lawyer generates inequality that is non-acceptable, not so much for what the judge might or might not do, but because truly the defense is not sufficient, is it? So the issue here is this tendency that is based on the economy, as Professor Zuckerman said so well. So it has to do with the economy. It means less expenditure, less cost, less judicial cost. But for us in Argentina, it's not so substantial because there is a regulation of fees. Lawyers can freely bargain for a plus, yeah? And they can do something else, but there are official fees. And every party, of course, decides what lawyer to go to and how much to pay. But there is an official regulation of fees. And yes, we tend to complain a lot because it's very low. Rather, we are not very well paid. Judges tend to kind of not meditate our task as lawyers. That's what we find. But anyway, my question, a fee regulation carried out by the judge, wouldn't that help towards kind of more inexpensive burdens, and that would make it possible then for all parties to have a good lawyer representation? Wouldn't it be a good idea? That's all.
Yeah? I am insisting in concretion because we have organizations tell me that we have 5 minutes only. And I'm so sorry.
Sí, está bien. Doctor, ¿qué tal? José Beristain de México.
Hello, I'm Jose Beristain from Mexico. Thank you very much. Over here, yes. My question is also in this direction. I understand then that one of the parties then is self-representing and the other has lawyers, then there's inequality. Yes. Well, in this, here what the judge tries to do with a more important activity is to balance out that substantial inequality in order to achieve true justice. So I understand what you say. Cost is the confirmation bias, about the impact on being impartial. But don't you think that that bias and that cost could be controlled with a really intention in the sentence that can project this reasoning and make them exterior, make them go through a document that eventually could be reason of control for a second instance, and then balance out these two aims, both equality in the judicial procedure and the decision-making process, and second, to better control this partiality of who judges?
Buenos días.
Hello, good morning. My question is addressed to know about your experience, Dr. Zuckerman, about the confirmation bias that has relation with external actors to the process. Because yes, you said that there is this bias. Maybe in the case of England, you talked about a judge who had to leave because she was the sister of somebody involved in a rape case. I come from Ecuador, and in our case as well, there are many processes started on the basis of sexual crimes, sexual offenses, and the confirmation bias comes really mediated through society, because society is demanding from the judge a sentence. Because if not, well, it's necessarily... Please, you have to be brief. The question, I'm sorry, but we have 3 minutes. Go to the question. What's the question? Only one question. Yes. So what's your experience regarding confirmation bias that comes through external actors such as society, when society is looking for a specific decision that the judge has to give, and if not, then the judge maybe is risking?
No, it's not possible. The Professor Daniela Catino, the question, I don't know, at the beginning. The last word is Professor Daniela Catino. There is no more questions. Daniela Catino. Daniela Catino, I'm so sorry. It's the first of asking the question.
Well, very, very short, just to know if there has been any discussion from the point of view of Human Rights Act and due process on this new legislation.
Thank you.
Thank you.
Thank you. Professor Zuckerman.
Yeah.
I'm so sorry, because it's a lot of questions.
That's fine. That's fine. Right. I think that the lady from Argentina made a very good suggestion of fixed fee litigation, capping fees, because at the moment the fees in England are not capped. You know, to go all the way to the Supreme Court can cost you £1 million. So that's a very good suggestion. I have made it myself 20 years ago, and nothing has happened. And nothing will happen in my lifetime. Now, the gentleman from Mexico asked about balancing. Well, one litigant is represented, one litigant is not represented. Can the judge just balance? Well, that's the idea, to balance. But even in this act of balancing, you create a commitment, or you are likely to be influenced by confirmation bias. As far as external pressure and the person from Ecuador, the public expectation of particularly severe sentences for rapists and sexual offenders, yes, of course, that puts pressure on the judge. But that's not a question of confirmation bias, but that's a question of judges responding to evolving moral standards, which they have to represent and reflect after all. So I don't see anything wrong with that. And Daniela, yes, well, we have had, the King, yeah? We have had problems with ECHR and legal aid, but apparently the abolition of legal aid, in most cases, there are few exceptions, the abolition in most cases has not been challenged before the European Court of Human Rights.